Good morning, everybody. Thanks for coming on a Thursday. I know 2-hour presentations sometimes sound daunting, and we are going to cover a lot today. Shirley, does that look correct on your end, my screen?
Yes.
Perfect. Okay. I am not the most tech savvy person, as some of you guys may learn if I screw something up today. And if I do, I apologize. But today we're going to cover how to start a brokerage. That's going to cover quite a few topics. And so I'm not going to be able to talk about every potential issue that may come up when you're starting a brokerage. Well, my goal today is to kind of give you a really good overview so you know exactly what to do. And if you don't hear the answer to something today, I'm going to give you the tools so you know where to go to find the correct information. If you have any questions today, you are welcome to put those in the chat, and I will do the best I can to respond to those as we move along. However, no, I may address some questions at the end. It really all depends. But my name's Melissa Engle, and let me get over here. I'm a partner at White and Bright, and so we are a real estate litigation and transactional firm here in North County, San Diego. We've been going on for over 40 years. My role in the office is I'm one of the partners that covers representing agents and brokers in all different forms. So I help you guys with transactions when you have questions. I help you prepare forms if you need to, disclosures. I help you if you get sued. Unfortunately, I do a lot of non-disclosure cases. Those, as you know, are pretty common, unfortunately, in your area. Um, I also help with accusations from the DRE. If you ever receive a complaint or an inquiry letter, I'm your girl for that. I deal with title issues. I also dabble in employment law, so I'm your go-to person for any employment questions. My firm also does other kinds of real estate disputes. We do easements, boundary disputes, title issues, like I mentioned. We also have a trust and estates wing, so we can help people with those issues, both administrative, litigation, and assistance in real estate transactions. So you'll notice today I'm going to talk about the DRE a lot because when you're starting a brokerage, suddenly you have a target on your back, right? There's this entity out there that is watching you and making sure you are compliant. And so you'll hear some DRE horror stories today, and it's not totally to scare you, but it's to prepare you so you don't find yourself in those situations. All right, so today, my overview, I'm going to try to cover, like I said, as much as I can in 2 hours. And the big items are these 4 areas, both the DRE requirements on how to start a brokerage, business practices, and this is a big topic that's going to include both licensing, broker, the brokerage itself, monitoring licenses for your agents, forming the actual brokerage entity, which is also its own thing, hiring and firing employees and independent contractors, another big topic, as well as your broker agent agreements. I'll tell you right now, PAR does have a lot of good forms, and you're going to want to use those independent contractor agreements. You'll hear them called ICAs a lot, but you're going to want to add to those. And so we're going to talk about what I recommend there, as well as your broker supervision. You've got a lot of rules under the DRE rules, as well as just general California law about how a broker should be supervising real estate transactions. So I want to kind of cover that, make sure you're comfortable. Policies and procedures for brokerages. And I'll hammer that a lot because when I find brokerages that get in trouble, they usually don't have written policies and procedures. And I'll tell you right now, when you get sued as a broker, that is the first question that is asked. Advertising, as I'm sure some of you may already know, there are a lot of advertisement requirements for the DRE. So we'll cover those as well. We're going to talk about commissions and both antitrust laws. Trust records, I'm not going to spend a whole lot of time on trust records, but for those of you who are considering getting into property management or are in property management, just know that trust records are really, really important to make sure those are maintained regularly and accurately. And I'll go over that a bit, but like I said, I'm not going to spend a ton of time on it because it's kind of its own issue and it doesn't really affect most brokerages because I would say right now maybe 5% of brokerages also do property management, maybe even less. But if you have specific questions on that, obviously always talk to a CPA or an attorney, and we'll discuss that more when we get there. And lastly, license due diligence and potential revocation. We got to talk about what happens if the DRE comes for you. So we'll discuss that at the end. And I'm also going to touch on E&O insurance as well as file retention for brokerages. Because as some of you may know, the DRE does have requirements as how long you need to keep records for each transaction you guys close, even the ones you don't close that you were involved in some way, whether you had an agent that was, the listing or the buyer or what have you. But there's also other areas of law that want you to retain records for longer. So we're going to talk about that and what the good rule of thumb is there. All right, so you're here today probably because you're thinking about starting a brokerage or you have started a brokerage. First thing you want to do is ask yourself a whole lot of questions. And one of the first ones will be, who's going to be your broker of record? If you already know that person, great. Make sure they've got their license in place. You're going to want to register them with the DRE. If you don't, you got to figure out who that person's going to be, if they're going to be comfortable with supervision, all of those things. What software are you going to use? As we know, this is an industry that's very software driven. We use DocuSign, we use Glide. There's all kinds of different softwares out there. So you want to make sure you use something that's going to help you not only keep track of items, it's going to keep a record of when things were signed, when it was sent to people, and that you can really manage and that it's retaining your records. That's really important, that it's going to retain them for a decent period of time. Property management, I'll touch on that briefly, but again, if you want to do property management, it's kind of its own thing. So you want to make sure you're ready for that because that requires trust accounting and accurate logs of that. Are you going to have an escrow company? A lot of brokerages now want in-house escrow. And if you do, there's an entirely different set of laws that escrow companies fall under that they need to comply with. And then there's a lot of laws relating to the referrals and kickbacks back and forth. And so you want to make sure you're talking to an attorney early on and getting all the advice you need there before you even consider opening the escrow company. Are you going to do commercial or residential? Most brokerages I speak to are primarily residential brokerages these days. That's usually the bread and butter here in San Diego County, but there are brokerages that do exclusively commercial. Or do a blend of both. And it's a consideration you want to think about early on because not only are those two transactions considered somewhat differently and different laws apply to both, but it's also probably going to cover or it's going to affect your E&O policies because the amount of money at stake when you're doing residential transactions is much different than the amount of money at stake when you're doing commercial transactions when we're talking about larger sales numbers. And so you want to make sure your policies are actually covering potential exposure there. So we'll touch on that as well. How will you supervise? This is one of the biggest issues I see brokers run into is, am I going to be in the office physically looking at these transactions day to day? How often am I going to have training with my agents? How am I going to monitor these transactions remotely? You want to make sure you're doing something and there is a procedure in place and it's actually being followed. And so we'll talk about tips and tricks there. DBAs, if you're going to have trade names for your brokerage, and we'll talk about this in a little bit, they got to be registered both with the county and with the DRE. And you also got to think about your E&O and make sure that DBA shows up on your insurance policy as well, because I've had many issues where a brokerage gets an insurance policy in one name, but then gets sued under the other name. And guess what? Your insurance company is saying, well, we don't represent this other entity, so we're not going to cover this. We're going to talk about how to avoid that. And are you going to have additional locations? Is there going to be multiple branches? Another thing to consider. Again, this is not all the questions you will be asking yourself, but these are kind of the major ones. The other thing I always tell potential brokers when they're looking to start their brokerage is assemble your team. You need your Avengers team of people that are going to help you because trust me, it takes a village to create a brokerage. First person And I would love to say the attorney's number one in my mind because what I do. But the first person in my mind I think you need is a CPA. They need to tell you how you're going to be taxed, how you need to be set up, um, and just your initial business considerations. You want that person in place to start the accounting off correctly and precisely immediately. Then you want to talk to your attorney. The attorney is going to help you actually form your business entity. You need to register the corporation with the state and with the county. Um, they will assist you in figuring out how you want to structure your entity. You also want to get them on board with helping you create your policies and procedures, looking at your ICA agreements with your agents, and just generally helping you build the business base so that you are proactive whenever issues come up, not reactive when you get sued later. I always tell my clients, I want to hear from you before a lawsuit's ever filed. I want to hear from you during the transaction when the issue comes up, not afterwards, because we can't do much about it afterwards. Then we're just playing defense. Um, Having a good attorney up front helping you proactively set things in place is the best way you can avoid lawsuits in the future. Um, you want to have an insurance broker as well up front, somebody out there helping you to obtain the right insurance at the right price for you with the coverage you actually need. Um, and brokers are fantastic for that. There are so many companies out there that sure you could do it on your own, but really a broker is going to find you the most reputable company out there at the price you need. I can't stress it enough. A broker is perfect. If you're going to be doing, again, if you're going to be handling money for property management, you set up your trust account right away. It's important to know that a trust account is not a basic business account at a banking institution. It's an actual specific type of account. And so you got to make sure you're opening the right one and going to whatever your trusted banking institution and telling them what you need to do. They can assist you and make sure you open the correct account. You got to think about what software you're going to use. Again, we're not talking just Dropbox and Glide and all this stuff to help you do your transactions and coordinate those. We're also talking about your accounting internally. Are you going to, use one of the typical Intuit or the typical at-home software to help you with accounting, or do you want to use something different? Or is your CPA going to be handling all of that? You want to think about all of that. And again, this is not all inclusive, but really to me, if you get your CPA, an attorney involved, and an insurance broker involved up front, you're well ahead of the curve, and that should help you really get started. Is there any questions so far? Let's see. I can't see. Hold on. All right. I'll check in just a minute. All right. So first, let's start with licensing because that's kind of the basic front issue is, okay, I want to start a brokerage, but I need to get my broker's license. Some of you may already have one, some may not, but I will go through this area a little bit quickly just because a lot of this is on the DRE website. And I bet a lot of you kind of already know this at this point, but I've left the address for the website of where you can find all the brokerage license requirements up top. But in short, you've got to be 18 years old. You've got to be able to have a social security number that you can provide. And for experience, you need to have a minimum of 2 years full-time licensed salesperson experience within the last 5 years, or the equivalent is required, or 4-year degree with a major or minor in real estate. And there's a bit more information about that online, but typically most people fall under the 2 years experience. The other item I really want to point out is this honesty section. If you've ever been convicted of anything, whether it's a misdemeanor or felony, you must disclose that on your license application. There is there's some confusion out there about what it means, because one of the issues I run into a lot with real estate agents and brokers is that there's such an emphasis on crimes, accusations, allegations that involve fraud and dishonesty, that sometimes agents, when they're doing their applications, feel that they only need to disclose crimes relating to that. And that's not true. It's any conviction. The failure to disclose a conviction may result in you not getting your license, or it's going to put a target on your back in the future, even if the DRE gives you a license. And a perfect example I have is I had a client back in the day who had a DUI and didn't disclose it because he thought, okay, it doesn't relate to fraud. I wasn't being dishonest. I just, in my 20s, got a DUI. It happens, right? And so he failed to disclose. The DRE caught it. And ultimately, the DRE still approved his application. Unfortunately, he had a conviction later, and guess what? We're talking about that issue with the application all over again. So you don't want to not disclose things up front. Chances are you're going to get your license without issue, even if you have a conviction in the past. So be upfront about it. That's the best way to go. The DRE is a government entity, so they are going through all of the different databases that we don't have access to. They're going to find your convictions immediately and question you about it. So just be upfront. I'm not going to go into these in detail, but as most of you guys know, because you probably already have a salesperson license, you've got to do bunch of different courses. And so all the courses are listed here. The only item I really want to place emphasis on is you'll note that I did a little note at the end with the asterisk. As of January 1st of this year, you've got to have a course that has a component of implicit bias and fair housing training. So just be aware of that. That's coming up a lot. That's coming up even in my profession. That's a new requirement for us too. There's going to be a lot of more training probably coming on biases. And so just be prepared for that and make sure your courses adhere to that. Okay, so say you got your brokerage license or your broker's license, and now you want to open the brokerage. Not quite yet. Your brokerage needs to be licensed. So you got to do a DRE application for that. To do that, you first must become a corporation, and we'll talk about how you do that in a second. But you can't be an LLC, you can't be a partnership, you can't be a solo, you have to be a corporation. That is the DRE rule on that. So please be aware of that. And you must have the DRE issue a license. It's in the actual brokerage's name. If you have additional branches, each branch must have a license, and you must actually register each DBA you use. All team names, all trade names need to be registered. This is a violation of the DRE, and they find out later, they will come down on you for it. It's not the worst thing in the world, but it's not great. And I would build it in as part of your practice to always double check to make sure all DBAs are disclosed to your insurance. So it's actually listed in your policy. And with the DRE, I would do that maybe twice a year. Set up a tickler on your calendars where you go and check, okay, do I have all of my agents' team names? Are they listed on the DRE website? If not, let me submit the paperwork on that. And same thing with your insurance. It's best practice. And lastly, when you register your brokerage with the DRE, you've got to designate a responsible broker of brokerage. And that person's going to be, they're going to be the person responsible for supervising all of the salespeople. You can include additional licensed brokers, officers to do that. You're also going to provide a certified copy of the corporate resolution that designates that broker to do that. An attorney can help you create that. It's a very simple form, but the DRE will want that as well, just to make sure that the company has actually given this person who's been identified as the broker the actual authority to act as the broker. But what about licensing when you're dealing with your other agents and brokers at your brokerage? I run into this issue so often. What happens is many times the DRE may suspend somebody's license, saying a real estate agent license that works for you. Say that person failed to pay child support and that person got suspended. No one got the letter in the mail. Nothing happened. That agent went on to close transactions. And then suddenly my broker calls me up and says, I just got an accusation from the DRE saying I had an agent without a license closing transactions. And now we're all being accused of this by the DRE. This happens a lot. And the DRE is an entity that doesn't have a ton of money, but They really like these easy kind of things that they can prove. That it's easy to prove that somebody closed a real estate transaction when they didn't have their salesperson's license. It's two forms essentially for them. They don't even need testimony on it. For them, even with their low budget to actually go out and enforce, they can do this fairly easily. So they love to look for these. So I always tell my brokers, I strongly recommend quarterly, and I would just schedule a morning quarterly where I go on the DRE's website and I check and make sure all of my salespeople still have active licenses. Because I hear this way too often, and it's very troubling to me that I didn't get the notice from the DRE that they were going to suspend my license, or they did suspend my license. I hear this from agents, brokers so often that I do question if these notices actually go out correctly by the DRE. They don't send them via certified mail, so there's no way to track them. They just regularly mail them. And so there's an appreciable chance that you might not even get notice if something's going on. So I would strongly recommend, again, quarterly kind of auditing this. And it doesn't take that long when you, even if you have a bunch of agents, I mean, you're just inputting real quick just to make sure. But you want to do that and you want to be proactive, because one of the issues I always tell my brokers is, even if the DRE catches you on something like this where it feels ticky-tacky, you're like, oh gosh, really? This seems silly. They're going to obviously get their license reinstated right away. DRE is still going to then ask for all of those transactions. They're going to audit all of them, and they're going to look for any other potential violations they can nail you with. So you don't want that door to open ever if you don't have to, because while we all strive to be perfect, mistakes are made. We're human, right? And so it's very likely the DRE will find something else to take umbrage with. So rather than deal with that, let's just make sure everyone's always licensed. And like I said, I get a significant amount of calls on this issue a lot. The unlicensed salesperson who closed a transaction. DRE loves these. I cannot stress that enough. Another thing to make sure when you are auditing, I always check in. I always tell my agents and my brokers check in, make sure everyone's doing their continuing education, make sure everyone's getting that done timely. That's usually not an issue for the most part. Most of my agents are good about that, but you know, sometimes people forget things, life happens, and so it's always good to check in. Again, you want to make sure, because you cannot pay commissions to anyone who has an expired, lapsed, or suspended license. But you also want to make sure when you're paying commissions to your agents, you're paying it to them individually. A lot of agents have their own business set up and they want to be paid through their business. And I understand why. There's tax implications for that. They want, to keep everything accounted for correctly. The problem is the DRE actually has laws on the book that say you have to pay the salesperson individually. So you must do that. I'll tell you right now, when I have people that get accusations, this comes up a lot. This is something that always the DRE discovers. And again, it's one of those easy things to prove that the DRE loves it. So make sure you're paying the individual. And before we move on from licensing, I just want to give some final comments. Again, you want to make sure when you do the entity formation, which we're going to talk about next, talk to an attorney and a CPA before you do that, because there are considerable tax implications involved that your CPA can help with to make sure you set it up correctly. And you want to make sure you're actually setting up the entity correctly as well, because corporations are a bit more formal. They have a bit more rules. And so you want to make sure you're acting within the confine of those rules. Because if you find yourself in a lawsuit later and you weren't running your business pursuant to the law, there's always the potential of a party doing what's called piercing the corporate veil. And what that means is if they feel you were using the company for your personal gain in some way and weren't following those corporate formalities, they can try to go after you personally. It's a high bar. I'm going to tell you right now, I very rarely see people prove this, but it's provable. And so you don't want to set yourself up for that potential. Again, we'll talk about insurance again, but always check with your insurance for compliance. Make sure the policy is in the correct business name. You've identified all trade names and DBAs. And remember, Car Legal is out there. Car Legal is great. I've called Car Legal and I do this for a living. They have attorneys that are so knowledgeable on staff that can really help you with issues, even the weird ones where you're like, I don't know if anyone has the answer to this. Car's probably seen it. So always feel free to call Car, because that's one of the issues when you're starting a brokerage, right? There's a lot of money on the end to try to start up a brokerage. it's easier said than done to constantly pay an attorney up front before you've even done a transaction. And so if CAR can help you with some of those basic questions, go to CAR. They might not be able to help with everything, but they can help you somewhat keep the cost down to start. Um, and again, always check the DRE's website before you submit any forms. They do tend to update certain forms regularly. Other ones have been around in the same form for years, but I always tell people, good rule of thumb, even if you have that form in your file, just go double check on their website before you submit it to make sure you're using the most up-to-date version. All right, so with licensing out of the way, how do you actually form your brokerage entity? As I said, you're going to want to talk to a CPA and an attorney. You can go online and use things like Legal, Zoom, and all those websites to create your own corporation. I recommend going an attorney. I know it's a bit more expensive, but the issue is just so many formalities with a corporation. You want to make sure you're doing it correctly. And so you need that kind of guidance a little bit. And I will say, setting up a corporation isn't as expensive as you think, but it is a cost, and I am aware of that. When you set up your entity, you're going to want to appoint officers. You have a CEO, CFO, COO, a secretary, things like that. You're going to want to think about who in your organization would be good for those roles. And if you're just kind of a small business starting out, it may be the same person for all of the roles. It may be answered for you, but you'll want to think about that. The first step to actually creating the entity is filing articles of incorporation with California on the Secretary of State website. And that's easy enough. It's a simple form. Then you're going to want to prepare bylaws, though. And bylaws are kind of your policies and procedures outlined for how you're going to run your business. There are corporate formalities where you have to have annual meetings to talk about appointment of directors, things like that. And so you'll want to have all that information in. You'll also want to think about things like, what's your 5, 10, 15-year plan for the company? If you're looking in the future where you might bring other shareholders in, you're going to want to set up bylaws that allow for that. Or if you want to keep your brokerage tight knit and you really don't want shareholders coming in later, you don't want people to have the ability to sell off their shares to a total stranger without you knowing, you're going to want to address that in your bylaws. And keep in mind, bylaws can be amended and restated as you move along, meaning that you can change the rules later, but you need all the shareholders to agree when you change them later. So it's good to try to get a lot of these questions answered up front and get that structure in place now, then do it later when there's too many cooks in and people have different opinions. You also have to register all owners of the business with the FinCEN federal website. That is a new requirement. It's actually up on appeal right now, so I don't know if it's going to continue, but as of right now, it is still in place. So if you are setting up a corporation anytime in 2024, you've got to do this registration within 60 days. And it's the federal government's way of just trying to figure out who owns businesses in the background. I think this came about because there was a question of a lot of foreign money coming into corporations. And so people were questioning where people are, who actually owns what entity. It's a fairly simple process. You just give your contact information and make sure that you're registered as an owner. Anytime you change your address, though, you got to update it. So you want to keep that in mind. Similarly, with the state of California, you need to file what's called an annual statement of information. This is actually very quick. It takes less than 10 minutes, but you're just confirming who the officers are year after year, giving any updates if those change, and whether or not there's labor judgments against you. It's a fairly simple process. You'll also have to do annual corporate governance. Again, those annual meetings, you just type up minutes. They're usually fairly simple unless you're making big changes, but a lot of times it's just reappointing the same directors over and over again if you're a smaller corporation. And again, throughout this entire process, you want to think about the tax implications because corporations can be taxed in certain ways. And so that's where your CPA comes into play. So you're going to want their guidance for sure. Also be aware, if you are using fictitious business names, those DBAs we talked about, not only do you want to register those with the DRE, but you got to register them with the local county. They need to be on file with the county. And then you have to have them 40 days from the time you actually start activity, meaning you need to register pretty much right away. As soon as you open up for business, you should go do this. There is a publication requirement in a local paper. I'm sure you guys have opened the papers before. We see the summons and the fictitious business names. There's like pages after page of that. That's what that is. You got to do this publication. And then you must make sure that the DRE also has that fictitious business name listed under your license as well. And so you want to make sure, again, you're just auditing that, whether it's seasonally or twice a year, something you want to check on. Again, remember, you can only be a corporation. So always keep that in mind. Every once in a while, I have a brokerage come to me that's accidentally registered as an LLC. We can fix that. We can fix that quickly, but just more paperwork and money. So you really don't want to just set it up correctly to begin with. Local business licenses may be required. It depends on your municipality. City of San Diego requires them, for example. So just make sure you're checking in with local laws if you need to register at the city or county level in some way. So just be aware of that. Attorneys can help you with that as well. All right, so let's talk about, I can't see if there's any questions. I'm so sorry. I'm going to end my slide real quick. Any questions? Oh, I can't. Okay, I can't see. All right, let's go ahead and go back. All right, I will check for questions at the end. I'm sorry, for some reason the little chat is not popping up on my end. But let's talk about employees. So after you've done all this stuff, you've finally incorporated your business, you've got everyone licensed, you've figured out plans and procedures about how you're going to supervise, and we'll talk about that a bit more, but you've finally done all that. You're exhausted, you've spent a bunch of money, you're ready for a vacation already. But you got to make money, right? You got to actually start doing transactions now. So you need to get employees and independent contractors in. And there's two types of hires. It's the employees. So that's probably going to be your actual office staff, if any. And then your independent contractors, which are going to be your salespeople. Salespeople are generally independent contractors in California because they're exempt from those employment requirements. CAR actually went and lobbied to the state to make sure they were always exempt. And so that's why you have those independent contractor agreements with your salespeople. You need to make sure that you have those written agreements with all salespeople because they are a requirement. Again, I would start with the CAR form. It covers a lot of stuff. It's actually very well written, but it doesn't cover everything. And we'll talk about how you probably want to amend that, add a bit more, especially as to commissions. And referral fees. Also, if you're working with Zillow, if there's going to be splits after termination, these are all considerations you want to think about. But remember, for compliance purposes, you have to let the DRE know within 5 days of an agent becoming affiliated with your brokerage that they are indeed working for you now. You can do that online fairly quickly. Now, one of the things people get into trouble with is who's an independent contractor versus who's an employee. Luckily for real estate brokerages, like I said, salespeople, it's a given. They're independent contractors in the law here. So that's easy for you. But what about everyone else? They're probably going to be an employee. And I would make sure that you are consulting with an attorney to make sure you have the correct classification and exemption for them immediately. Because if they're employees, generally, unless they are a salaried exempt employee, and that's for a limited type of person, they're entitled to meals, rest breaks, overtime, and all that stuff that needs to not only be tracked, but actually paid out correctly. Because again, those are easy claims that a disgruntled employee can bring later that are easy to be proved if they weren't paid correctly. Also note, independent contractors can be transformed into employees, and I'll talk about that in just a second. The test here in California to determine whether or not somebody should be an employee is what's called the ABC test. And you want to ask yourself the following questions. Is the worker free from control and direction of the hiring entity in connection with the performance of the work under the contract for the performance of the work and in fact? Meaning, you don't just write it down in their agreement that, yeah, you have control, you can go do this however you want, and then you're constantly micromanaging them and giving them, deadlines and limitations on how to do things. Because that's, again, going back to how you can kind of transform an independent contractor into an employee is if you start doing those kind of things and kind of treating them like an employee that you can control more than you should. So that's step one. You got to meet that factor. The worker also has to perform work that is outside the usual course of the entity's hiring business, meaning they're doing something you don't typically do. For example, if you hired an accountant for your company to come in and do stuff, that's probably not what you typically do. You're a real estate brokerage, right? And so that person might be an independent contractor. The last element you need to meet is that the worker needs to customarily be engaged in an independently established trade, occupation, or business of the same nature that is the work they're performing for you. And so what that means is they've got to have a business open. They got to be doing this stuff for other people. So as you can see, to meet these three elements, most people are going to be employees. It's very rare that they're not. And then, like I said, obviously a salesperson is a complete exception. They do not need to be considered an employee. However, and this is important, you're going to want to have workers' compensation insurance. And as far as workers' compensation goes, salespeople are considered employees for the purposes of workers' compensation. So you want to make sure that covers them. You want to maintain this insurance just in case anything ever happens, because this would cover if there's an actual workplace injury, if there is an injury out at a property that they're supposed to be at as part of their job, things like that. And it does come up, so you want to make sure you're covering that. I know we didn't spend a ton of time on employment law, but what I really want to tell you guys as a takeaway to consider moving forward is that employment law in California is a beast. It is one of the few areas of law in here in California that's constantly changing, meaning new laws are coming out, new case laws coming out that's changing things. There's a lot of areas of law in California that haven't changed in decades. Even real estate, there's been some developments, but it's overall pretty static. The same rules kind of tend to apply decade after decade. That's not the case with employment law. California is very employee friendly, and it tends to change with whoever is in charge, whether that's at the federal level or at the state level. People's proclivities tend to guide how employment law evolves here in California. So I would have an employment law attorney on speed dial if you have employees, because you want to make sure that they are giving you the most up-to-date information about employment law to make sure that you're actually doing things correctly. Because just because something's legal right now and that you can do it, it doesn't mean you can next week. There might be something that comes up. I even find myself, and I do this day in, day out, where I start to go double check things and I realize something passed that I didn't even catch. It happens more often than I'd like to say. I have to tell my clients a lot that I always have to go double check this area of law just because it's so quickly evolving. But get that person on speed dial. Make sure you have an employment lawyer that you are comfortable with if you have employees. All right. I got the chat. Hold on. Let's see what we got. So TCs and photographers, no. The question is, if you bring a photographer, a TC, or anyone that makes over half of their income from you, they will become your employee. Not always the case with photographers. Photographers are tricky. It depends if they have their own fully formed business and you're not really controlling them. They can kind of show up whenever. TCs must have their own contract with you. And there are situations when TCs will become employees. And William brings up a good point where sometimes if they're getting over half their income from you, they may become an employee. But again, that's not a hard and fast rule. So I would make sure, again, you talk with an attorney on that. And I have another question from Julia. She says, I had a corporation set up while practicing as a salesperson. I was planning to continue using it for the brokerage. Any issues with that? Probably not. But you're going to want an attorney to look at your bylaws to make sure they cover what your new business is. And so a lot of times in bylaws, they may say what your business is going to do. So you want to make sure that actually covers what you're now going to do. Check the bylaws to see if you need to amend anything else for this new type of business. And then check with your insurance to make sure it's actually covering what services you're currently going to be providing. Very good questions, guys. Thank you. All right, so I think I got everything. Yeah. All right, so the independent contractor agreement. You've identified some salespersons. You want to retain them. Again, as I mentioned earlier, you have to have an actual ICA agreement. It needs to be written, it needs to be signed by both parties. That is a CAR requirement, that is a DRE requirement. Review the CAR form carefully because, like I said, it's a very good form. It covers the major issues you need: indemnity, what the agent is or isn't allowed to do, how termination is going to be treated, um, how people are going to be paid. But it doesn't go into the details, like I said. What happens if a termination happens and they leave with one of your transactions or one of your clients? What happens with commission splits? What happens with referral fees? What happens if you have an in-house escrow and are working with that? What are the rules relating to that? So almost always you're going to have addendums to your independent contractor agreements. You're going to also want to review whatever activities you're prohibiting your agents from doing and make sure that that basically jives with your insurance coverage, and vice versa. I have had a couple brokerages that started doing property management and then ran into an issue and we go look at their insurance policy and their insurance policy doesn't cover property management services because they never updated their policy. You don't want to find yourself in that situation. So make sure if you're prohibiting an activity, it's in writing, everyone signs that knowing it is prohibited and that it complies with your insurance. And the other way around, if you're going to do it, make sure it's allowed in writing and your insurance is allowing it as well. Supervision. The agreement does talk about supervision briefly, but if there is going to be specific supervision you want, maybe like somebody has to give you a weekly account of where everything is at and every transaction they're on or whatever you're going to require, make sure you have that in writing too. I would tack that on to the ICA agreement. And you literally can have them sign the CAR agreement and then have an addendum that's in the back, basically the additional requirements that are just added on as an exhibit. Compensation. How are the splits going to be divided? If somebody's on a team and multiple people are working on a transaction. If you're dealing with Zillow or Redfin, what happens after somebody leaves? And again, they're midstream on a transaction. Automobile insurance. It's something to think about. Is somebody going to be driving around a lot? Are you going to be covering insurance? Are they covering their insurance? Do they get a stipend for that? You want to make sure the automobile insurance covers them for work-related stuff. A lot of auto policies, only cover personal, ingress, egress to places, driving around on your own personal time, going to and from home, going to the grocery store. It may not cover somebody during their work hours. And so you want to make sure that's covered correctly. You want to make sure there's termination by either party. Look, it's, either party should be allowed to go when they want to go. That's really important. And again, if there are personal assistants or transactional coordinators, they must have their own written agreements as well. Always audit, make sure your agents have those written agreements with their TCs, because a lot of times agents want to use their own particular TC. That's fine. Just make sure they're doing it correctly. Oops. There we go. All right. So again, you want to think about the following. How are you going to pay out the referrals? How are you going to split? What happens when that agent leaves the brokerage? What happens to leads that contact them after they've left the brokerage? Are there going to be activities that you want your agent to participate in? And the important one is mandatory trainings. What trainings do the agents need to go to? What requirements are you going to have for advertising? Do you want the agents to use specific logos on their advertising? Do you want them to not advertise on, say, Instagram? Maybe you just don't want to do that, or TikTok or something. You want to make sure, you think about those things. How are you going to handle open houses? What about agents' individual web pages? What must they have on those and what must they not have on those? What activities you're going to prohibit? What logos you want to use and when can they use them? When you prepare these, I would have an attorney not only help you, but audit these annually. This profession evolves, right? We all know, there was the NAR ruling that came out earlier this year that's changing stuff. There's things like that all the time that change your policies and procedures, or you're going to run into an issue with an agent that brings up a question or a circumstance you never thought about until it occurs. You want to address that in your ICAs. These are living documents. They're not set in stone. It's not unusual for brokerages to change their ICA agreements annually. So don't feel like you're stuck with something after you draft it. Also keep in mind, however, there are non-competition and non-solicitation requirements in California. And you want to be careful if an agent leaves, how you structure the agreement, say if a lead comes to them, because generally the public is free to work with whoever they wish to work with under certain circumstances. And if an agent takes off with your client list and purposely contacts each of those clients off of that list and gets work from it, you might have a claim and you have a right to that compensation, a right to at least part of that commission. If a former client just contacts that agent after they left you unprompted, you may not have a right to anything because that runs afoul of the non-solicitation laws here in California. This is an area law again that's evolving here in California, but California generally hates non-solicitation provisions. And a lot of times some ICAs will have provisions that don't say they're non-solicitation, but their effect is. And so having an attorney look at this to make sure it's compliant is good, so you don't run into lawsuits about that issue later. Broker supervision. Now you've got your ICAs in place. I want to talk briefly about what broker supervision is here in California. And I put some of the law here, and I'm not going to go over this, a whole lot, but it talks about, how you have to do background checks, fingerprinting, administrative hearing processes, supervision requirements. You can kind of look at this code and get a brief rundown of what it all entails. But really, here are the main hit items. As the broker, you're responsible to ensure all licenses are up to date and active for every salesperson in brokerage. You must maintain their licenses or the actual physical licenses in the office for the brokerage. Salespeople can only be paid by their broker, individually paid by their broker, not to their corporation. And referrals must be paid broker to broker. I do see some people run afoul of this. There are some exceptions, they're minor, but brokerages are always the people that are ultimately responsible for transactions, or the entities, I should say, and therefore they need to be paying the referrals and would be paying the commissions. Additional to supervising is, okay, how do you actually supervise the transactions? And you can see as a broker, you got to oversee quite a bit. Any transaction requiring a real estate license, so that can be any purchase or sale, including, property management as well. You need to review documents which may have a material effect upon the rights or obligations of a party to the transaction. This is really subjective and extremely broad. Broker is also responsible for maintaining the documents, filing and storing them. If there's going to be trust funds, meaning you're doing property management, the broker is ultimately responsible to make sure the accounting is correctly there. Even if you outsource it to somebody else, you can't say, oh, my accountant screwed up. The buck stops with the broker. And so you want to make sure that's being done correctly. You got to make sure that your salespeople are up to speed with all federal and state law requirements. And especially relating to discrimination and all its forms. That's a big hot area right now. Equal housing is, you notice it's coming up in the educational requirements. It's becoming a hot button topic. And so you want to make sure you're providing training on that. And then you want to make sure you're getting regular and consistent reports of the activities of your salespeople, meaning that you are tracking their transactions and you know what is going on. All right, other things to think about. When you have a small brokerage, maybe you have 10 salespeople or less, it's pretty easy to supervise, right? Because there's only going to be so many transactions going on at a certain time so as a broker, reviewing those transactions is easy. However, once you get bigger, you're probably going to need a system really put in place to help you with that. So think about a system that would work for you. I would say create an actual schedule of when you're going to review things, making sure you're reviewing everything before close of escrow, before releases of contingencies, making sure things are done correctly on transactions, and that all the correct forms have been signed by all parties. And you can use the services of other brokers that you hire to do that. but you can't relinquish your overall responsibility for the supervision as the broker of record. You're ultimately the person that is responsible for everything, but you can have assistance in this area. So the minimum requirements for supervision, I provide the law here in case you want to look at that. Again, a broker can delegate responsibility and authority to of non-licensed persons under this section, and I kind of give you the requirements there and what that person needs to have. That person needs to be registered with the DRE. And again, I would strongly advise, if you're going to be a brokerage with 10 to 15 or more salespeople, have a second person to help you and get that person delegated on the DRE website. All right, a lot of you guys probably know about the broker disclosure requirements. You probably had a ton of classes on this, but I bring it up here just because I would say 80 to 90% of the calls I get on lawsuits are non-disclosure cases, almost always. And so it's so important for brokers to not only understand the legal rule of thumb here for disclosure, but also regularly getting training for your associates on this issue. And I would say at a minimum, you want to make sure your salespeople are getting an annual training on disclosure. And preferably by an attorney who's going to share horror stories to scare them a little bit to make sure they're doing things correctly. But here I want to read this code in full just because this code governs so many real estate disputes I have, and it's California Civil Code 2079. And it says it's the duty of a real estate broker to a prospective purchaser of real estate or residential real property to conduct a reasonably competent and diligent visual inspection of the property offered for sale and to disclose to a prospective purchaser all facts affecting the value or desirability of that property, and that an investigation reveal if that buyer has a written contract with the seller to find or obtain a buyer, or as a broker who acts in a corporation with that broker to find or obtain a buyer. So really what it's saying is you guys got to do your visual inspection. And again, it's only a visual inspection. You guys aren't hopping on roofs. You're not climbing under homes. You don't need to look what's going on in the walls, but you need to do a visual inspection. And this is not my non-disclosure course, but the biggest takeaway I tell every real estate agent and broker when you're doing visual inspections is when you're filling out that AVID, note every single defect you see. I sometimes see, and I see brokers run into trouble because of this, AVIDs where it's talking about all the upgrades and the remodels. It's almost reading like a sales document. It's a sales pitch. You're already under contract to sell the house. You don't need to try to sell the house. Or I see AVIDs that are what we call clean sheets, where it'll say literally nothing, or on each line somebody writes nothing noted, nothing noted. Even if property is brand new construction, you're going to find scratches on the wall. You're going to find dents in places. You're going to find smudges. You're going to see discoloration. You're going to see something that doesn't look level. Note everything. This is how you save yourself if there is a dispute later, by having an AVID that actually calls out issues. Because once you put your buyer on notice about potential issues, they are under the obligation to go investigate those issues. And so I cannot stress enough, you want to make sure your AVIDs are anything but clean. Note everything. And similarly, if you ever learn something that might affect the value or desirability of the property, which again is extremely broad, that can include neighbor disputes or nuisances in the area. And a nuisance can mean a great many things to different people. It could be the neighbor that smokes pot next door. It could be the marching band at the high school across the way. Whatever it is, disclose that stuff and disclose it in writing. And I would preferably do it in an actual disclosure document, or alternatively in an email. Some agents like to do it via text, and while that's generally fine because it's writing and it's something we can bring up later in a hearing if we needed to, text messages tend to get lost or deleted. So, and also it's a pain in the butt to download those and save those in every single transactional file. I'll tell you right now, salespeople don't want to do that. So do it in email and save all those emails, because again, what might affect the property is a broad and subjective issue for everybody. And so you want to just make sure you're disclosing more than you have to, even if you feel you don't need to, because it's better to disclose in case there's a lawsuit later, just frankly. A little bit more on broker supervision. I know the business and profession code that talks about reasonable supervision. There's no bright line rule for this, but really brokers should be reviewing, initially, and dating all documents signed by their salespersons really within 3 days. Not all brokerages do this, but you should be able to say with a straight face, like, yes, I reviewed and approved this. But also, this is a big one, MLS compliance. Whatever is written on the MLS is treated as gospel, and the buck stops with the broker. And so you want to make sure whatever is put on the MLS is accurate and that your seller has actually physically reviewed it and signed off and approved on it. My good rule of thumb, I always tell my brokers, is I like to send the draft MLS listing to the seller, and you can do it via DocuSign or email, and make sure they review it and ask them, do I need to change any single word here? Is anything inaccurate or misleading or incorrect in any way? Just make it as broad as possible and let them know that this has to be accurate. If there's an issue later, this is something that would be cited to. So I put the ownership on the seller to really approve things. And then lastly, you want to make sure you're up to speed with your local code of ethics. It might be your local association, like North County Realtors, or it might be CAR, what have you. Make sure you have those codes of ethics and that your salespeople are regularly reviewing those as well. For the most part, they don't change drastically year after year, but they do change sometimes. And a lot of times they change based upon new technology coming into play or a new law. So make sure you're just reviewing those regularly and providing those to your salespeople. All right, policies and procedures. We mentioned this briefly. You should absolutely have written policies and procedures. Like I said, if your salesperson finds himself in a lawsuit on a transaction later, whether it was non-disclosure or some other issue, maybe the transaction didn't close for some reason. One of the questions, the first questions one of the attorneys in that case is going to ask is, where is your policies and procedures? You want to have those in writing and be able to produce them, because that shows, yes, I was supervising. These are my guidelines, how I supervise. These are another thing, right? I would say I tell my brokers either in December or beginning of January, review your policies and procedures along with your ICA agreements. That's the time to do that, to make sure everything's still working for you, everything's still compliance. And consult with counsel to make sure you're following the latest DRE rules. If you need to, you can also look online for the latest DRE rules. Sometimes they're more confusing than others, but if you have any questions, that's where a real estate attorney comes into play. And again, I put it here, your written policies and procedures are the first thing a judge or jury might look at if something has to actually go to trial. You want to make sure you're also covering as much as possible. So again, this is one of those things where you want to think 5-10 years ahead. Really think about what your advertising should or shouldn't look like, your DRE licensing compliance for your salespeople, whether or not you're going to allow dual agency. We know agents love dual agency, but it's also a hot button topic, and attorneys love to sue on dual agency transactions. And so your risk factor in doing dual agency transactions increases probably tenfold than when you're just representing a buyer or a seller. So think about the rules relating to that, how you want to govern that with your salespeople. Maybe you want to set up a way where you're monitoring those transactions just a bit more than others, just to make sure you are compliant. How are you going to handle open houses, commission splits, vendors, disclosures, all of that? You want to think of a comprehensive list of things that will come up in transactions. So just to summarize, when you're a broker, you want to make sure you're reviewing the DRE commissioner regulations regularly, as well as CAR legal memos on broker supervision and licensing issues. Review your E&O insurance policy. I would do this at least once a year to make sure, again, your coverage is sufficient for each claim. All your DBAs are in there, and it's actually covering the activities that you're doing. As a broker, you want to make sure you're regularly doing your continuing education on these topics. You can always talk to your insurance carrier and your attorney for legal advice. I can't stress enough, CAR Legal's out there as well. You want to talk to CPAs, make sure your accounting's up to date, your tax stuff's in place. Um, and again, annually review and update your policies and procedures, as well as checking licensing status for all salespeople. Again, I would do this quarterly if you can. You want to be proactive. I cannot stress that enough. That is my rule of thumb with all brokerages is tackle a potential issue immediately before it becomes a mountain that you cannot control and is just outside of your control at that point. And suddenly there's a lawsuit and you're off to the races. You want to make sure you are addressing issues immediately and make sure your salespeople feel comfortable coming to you with those issues. I find myself in a lot of depositions with salespeople and brokers, and I hear it time and time again where the broker's like, well, I wasn't told that this issue is going on. My agent didn't come to me. And I talk to the agent, and I can tell in the deposition when I'm talking to the agent that it didn't even dawn on them to ask their broker, hey, I need your guidance on this. And so you want to make sure you're fostering a culture of come to me with these issues. Let's deal with them now so we don't have a headache later, and the money that comes with it later, and the stress and just the strife. And so make sure your agents are being proactive and asking those questions in the transaction, not later. All right, so it looks like we're doing good on questions. Let me double check. We're doing good. Okay, perfect. All right, so federal fair housing laws. As I mentioned earlier, the Fair Housing Act is getting a lot of love these days. And it's something that all brokerages needs to comply with. And so when I'm talking about federal housing discrimination, I'm really talking about the Civil Rights Act of 1968, the fair housing portion of it, where it prohibits discrimination in the sale, rental, and financing of dwellings and in other housing related transactions. And the protected classes are race, color, national origin, religion, sex, familial status, including children under the age of 18 living with parents, or legal custodians, pregnant women, and people securing custody of children under the age of 18, as well as the handicap. In California, sexual orientation is also included in that. These are pretty broad topics. You want to make sure that you are giving your salespeople proper training on these issues. Keep in mind, put down here, there are exceptions for the 55 and over communities, obviously familial status, there's kind of a carve out for that. So we do have those communities that is allowed. But it's this law essentially that kind of crushed the buyer letters that we all remember, where a buyer would do their presentation with their cute picture of their family and talk about them. We no longer do that, and that's prohibited in transactions because of laws like this, because it can run afoul of discriminating against some of these classes. So you want to make sure, again, regular training on these issues. It's now part of your licensing training to get your license. So we'll probably see more and more of this come up in CLE training. Additionally, advertising. You guys have a lot of advertising requirements. The DRE actually does have really good resources on this to kind of walk you through. It's one of the good things on their website, but make sure you can't run any type of advertisement concerning the sale, renting, or financing of property that might discriminate any one of those groups I just mentioned. So you want to make sure you're compliant with that. I also have the NAR rule down here that you can't run a statement or advertisement in any circulation that indicates a preference for any one of these groups, or for people not part of any of these groups. That's also discrimination. So you want to carefully look at things and make sure you're not running afoul in any way there. Similarly, there's sometimes commonly used words or phrases that may violate the advertising provisions. The Paralegal does circulations on this as well as DRE, so you want to make sure if there's suddenly a word you're not supposed to be using, you're not using it. For the most part, most of the advertisements I see right now are generally fine, but yeah, you want to double check that stuff. As the broker, I would make sure, this is another thing that I would kind of schedule annually, is go look for CAR memos and DRE memos on these topics, make sure your advertising is still compliant, and take classes on this and train your salespeople and employees as well. Another issue I do see come up a lot, though not nearly as often as non-disclosure or a lapse in licensing, is advertising issues with the DRE. And usually I see it when a salesperson has prepared and created a website the brokerage doesn't even know about. And it's just not compliant. It's just all over the place. It may even advertise for services your brokerage doesn't provide. Um, so you want to make sure you are asking your agents, I want to know all of your business websites so I can actually audit them year after year and make sure they are compliant. Um, as to the advertisements themselves, you need to have a DRE license to advertise. You want to make sure everything's truthful, nothing's deceptive or misleading in your terminology. I would always have somebody in your brokerage. I would say no less than 2 to 3 people should look at really every advertisement to make sure, does anything about this seem misleading in any way? Ask it very broadly and make sure it kind of passes that smell test, so to speak. You need to have your license number on it. The responsible broker's license needs to be on there. And if you're doing mortgages, you need your NMLS identifier on there as well. If you're advertising with the DBA, that must be a licensed DBA, meaning registered with the county. It's on your insurance, and the DRE has it on their licensing page. Team names are accepted, but I would frankly get team names registered as a DBA too, just because there's no, sometimes a team name versus a DBA, there's a question about, is it really a team name? Is it not? Just register team names. That way there's no question about later. Team names, however, do have their own requirements. I put the rule here to go check that out. And the other thing that you want to make sure is any disclosures you need to make are in the same font size as the advertisement. I'm sure a lot of you are older like me, where you remember the advertisements where people write what they call mice type at the bottom, where it's like in 0.5 font, and you need your monocle to go see what's going on. You can't do that. And make sure it's the same font size, any disclosure. When you're advertising, it must be kept current. Make sure everything's up to date, licenses are accurate, it's actually following the current laws, what have you. As far as your salespeople and advertising go, make sure you're aware that DRE may suspend or revoke a license of a real estate licensee who willfully uses the term realtor when they're actually not a member of NAR. This is ticky-tacky. I haven't ran into this issue for years, but it's technically still on the book. So make sure if you're using the term realtor, you're actually a member of NAR. Again, it's silly, but it is one of those issues that's technically you can run afoul of. And the real big issue with that, to me, is, like I said, the DRE doesn't have a lot of money to prosecute things. That's an easy one. If you're saying you're a realtor and you're using that term, they can easily go look to see if you're registered with NAR. It doesn't take them that much money and time or effort to do. So why give them an easy one? All right. So looks like everyone's doing well. How are we doing on time? It's 11:09. Okay. Antitrust laws. So we have a lot of antitrust laws, both in California law and federal law. And really, this is laws that are designed to kind of make sure we have competitive free enterprise and aren't damaging competition by creating internal monopolies with things, right? And so I have the comment here, every contract, combination in the form of trust or otherwise, or conspiracy and restraint of trade is hereby declared illegal. You cannot set up ways where people can only use your escrow company or only use your mortgage provider. You got to make sure free trade and free competition is protected. And so I gave some examples here. Examples: agreeing not to work with a broker who offers a 2% commission. Can't really do that. Can't do price fixing amongst brokers. You can't tell your agents that you should avoid using a certain vendor or not. So just kind of be aware of these. I'm not going to spend a ton of time on this stuff, but this is something you want to consult with your attorney. If you want people to use certain, vendors, you can announce, hey, we're gonna, hey, this vendor wants to work with us. You have an option to use this vendor, but you cannot say you have to use this vendor, or we're going to incentivize you to use a specific vendor. So just kind of make sure of that. You want to make sure your agents can really use who they want to use, and same with your buyers and sellers too. They might have a specific title company they want to use, and so be it. But just be aware that these violations are pretty serious. They're violations at both the state and federal level, meaning you can be sued either in federal court or state court. There are private causes of action for this. Possible criminal penalty of 10 years in jail and up to $100,000 in fines per violation is actually out there. If that, I haven't seen that personally be triggered, but that is the ultimate bomb of a violation. Similarly, corporations can be fined up to $10 million. Again, I don't think it would happen to your guys' corporations. We're not talking about $10 million corporations, but that is on the books. And there's more penalties. And so it's really important just to, I always tell my clients, think of antitrust laws just broadly. You just want to make sure there is fair competition and people can use the vendors they want to use. If you keep that as kind of your guidance, you usually won't run afoul of these laws. Other laws to be aware of though when you're starting a brokerage. Do not call, do not email, do not fax lists. These laws are awful because they are very easy to prove if somebody was violated, and there are just set damages in place. There is a set money structure of what you're going to have to pay if you run afoul of these. However, the legislator also realizes that these are difficult laws to fully comply with, and there's going to be innocent mistakes. And so I give the specific example here is you might be okay if a mistake is made, meaning one of your salespeople accidentally calls somebody on the do not call list, if you meet all these things. And so as part of your written policies and procedures, you're going to have rules in writing that your salespeople get educated and trained on about do not call rules. So you want to make sure they actually get training on that. There are MCLEs on that. And so they could take a course. I would absolutely require that and put it in writing in your policies, because that's one of the first questions a judge or a jury or an attorney is going to ask is, where is that written policy? Make sure you're maintaining and recording a list of telephone numbers that cannot be contacted, so everyone is aware of who they cannot call. You want to make sure you're using a process to prevent telephone solicitations to any telephone numbers on your do not call list, which employs a version of the National Do Not Call Registry. So you want to make sure something's in play where those numbers are not accidentally being called, whether that is setting up a weekly or monthly situation where somebody's combing through your client list or your prospective client list and pulling out people on the registry, what have you. You may have software that can do this. There's software out there also can do this, but make sure you have something in place that's kind of combing through and keeping things up to date. And then make sure, again, you're using a process to ensure that you do not use the do not call list database for any purpose other than compliance with state and federal law, and that you're doing training regularly with your salespeople. If you're doing all of these things, you have a good defense to a do not call claim, but you want to make sure you're doing that. One of the things I threw out here, and this is important, is Car Legal offers a proposed do not call policy sample. Or at least they did when I last checked. Hopefully they still do. As long as you're a car member, you can get that usually online. I would take their policy sample and just use that, because they're constantly training people on that and updating their policies. And so I would take what they have and kind of use that as your starting point. But note that, that policy may not cover every situation in your office. So you got to consider about how your salespeople are going about this and make sure you account for that as well. And again, these laws do change, so you want to make sure you're checking these annually, just like your other policies and procedures, to make sure they are compliant. All right, it's been 11:15 right now. I do have a bit more to go. It looks like we are doing okay on time. Looks like I have no more questions. So let's start with trust accounting. All right, so trust accounting. Most brokerages, if you're just doing residential real estate transactions, buy, sell, you're not going to be handling money. That's what escrow is for, right? So you don't need to worry about, excuse me, having a trust account or doing trust accounting. However, if you're going to be accepting money on behalf of clients for any purpose, and it's usually property management, you need to make sure you have compliant trust accounting of all deposits made at all times that's accurate and up to date. I would absolutely have software in place and have an accountant in place to handle that with you. The reason I say this is the DRE loves to audit people who do property management here in California because accounting is one of those easy things for them to prove. Again, it doesn't take a lot of time, money, and effort for them to do that. And so they love to audit brokerages that have trust accounts. If you are also a brokerage that has an escrow component, your side business, they're going to be auditing your escrow. Just assume if you have a trust account, you will be audited by the DRE at some point. And so you want to make sure you are compliant at all time because that audit can happen at any time. One, and two, if your numbers are out of whack, meaning they can't line up your numbers and correctly reconcile anything, any gulf in those two numbers, the broker is going to have to make up. The brokerage is going to have to figure out how to do that. And that means money may need to be put into the accounts permanently. I'll tell you one of the horror stories I had a few years back where I had a company that did property management and they had software that crashed. Excuse me. And then they had to recreate all of their accounting from scratch. Well, they really couldn't reconcile all of it. And the universe just delivered in that moment. Of course, the DRE comes knocking and wants to do an audit when they're trying to do this. And the DRE found a discrepancy of about, I think it was $23,000. And, the DRE immediately brought an accusation against the broker and the brokerage for failure to do correct accounting, failure to keep their trust accounts accurate. And the resolution is the brokerage had to put in $23,000 into the account. And until the brokerage could figure out where it was supposed to go, the brokerage could not take it out, meaning that money could stay there indefinitely. So you really want to make sure your accounting is up to date and that you're regularly checking it. At least quarterly, frankly. You should be doing a full-on reconciliation and checking things. But this is also why you want software. You want to make sure that software is backed up. That was one of the issues that brokers ran into is their software failed and there was no backup. You always want a backup just in case. Because the resolution of these accusations, they are resolvable. I've never seen anyone lose their license over a trust accounting issue. But the problem is the resolution is sometimes a lot of money. And so you don't want to put yourself in that position. It could be horrifying. All right. So you got your brokerage up and running and you are running your business, you're running transactions, you're doing well. What else do you got to be aware of? Well, there are many ways to lose a brokerage license, to lose a broker's license, to lose a salesperson's license. And so I put in a bunch of issues here that are on the books. Not all of these are going to apply to you guys, obviously, but the fraudulent taking and obtaining, appropriating, and retaining funds belonging to someone else. That's number one. Again, it's a rare issue. Forging or altering documents or uttering a false statement. This is a broad one. I've had a forgery case once. That's an issue. DRE, if they catch wind of it, want to know about it. Uttering a false statement can be pretty broad, right? That can just be a misstatement by accident. But those are issues that the DRE catches wind of it. They may want to investigate. Trying to willfully derive a personal financial benefit through the non-payment or underpayment of taxes. A specific one. Again, I don't see brokerages running issues of this usually. Just make sure your CPA is handling everything correctly. Escrow is handling the taxes on the actual transaction. Shouldn't be a problem, but be aware if that's on the book. Fraud, deceit, falsehood, misrepresentation. That's the number one thing I see people get sued on. A lot of times fraud is alleged in non-disclosure cases where, a spurned buyer will say, my broker and the salesperson purposely didn't tell me about X, so I would close the deal and they'd make their commission. Well, I think that's a bogus accusation. It's the most common accusation nonetheless, and so it's out there. Sexually related conduct with a non-consenting participant, that's technically on the books, so just be aware. If you fail to comply with any of the business or profession codes, meaning the DRE rules, that also can be an issue where you might lose your license or get a suspension. And if you fail to comply with the statutory requirement that you need to get from a government authority or a public authority, that also could be something that could be a violation. Other ones include if you're held into contempt of court or you've willfully failed to comply with a court order on something. Conduct which demonstrates a pattern of repeated and willful disregard for the law. That's usually if you've had multiple violations with the DRE. You know, if they see you on accusation number 3, they might be wondering what's going on. So those are kind of the overall ones. Other examples is how you might lose your license or you might receive discipline or suspension from the DRE includes failing to report a criminal conviction or pending charge. This is important. It's kind of obnoxious, but if you say you did get a DUI or a misdemeanor was brought against you for something silly, you have usually within 30 days, you got to tell the DRE what's going on. You got to give them a notice. There are forms online to do that. If you don't, the DRE is going to find out about it from those databases, right? Their databases regularly comb their licensee names and things will pop up. And so if they find out before from someone else about your conviction before they found out from you, they're going to bring an accusation on that topic. So if anything's ever pending, disclose. Another issue I've seen come up a lot is failing to inform a seller of all purchase offers to force the acceptance of your preferred offer. And this sometimes comes up innocently. I had a client who it was actually quite obnoxious. She had a real estate agent come to her and propose a hypothetical offer that he never conveyed in writing. And that got reported to the DRE and she still had to go to accusation. We still had to go to hearing. She ultimately won, but you want to make sure you're telling your agents about all offers. And I would say at this point, even the hypothetical ones that aren't real, because the DREs they love these kind of violations. Again, they see these as a big one. They're a bit more difficult for them to prove, but they're still going to go after them. Again, the other big one is practicing with lapsed license. Antitrust violations, usually something's in writing there, so those are easy for them to prove. Fair housing and discriminatory violations, those usually come up a lot when there's straight up advertising that violates that. And then crimes relating to honesty and moral turpitude. If you are ever convicted for something of, fraud in an unrelated context, it might come up and affect your DRE license. I would expect to get an accusation on that issue. So be aware of this stuff. Make sure you are training your agents regularly on this. If an agent ever comes to you with a potential conviction or they had an arrest, you got to make sure they understand they need to disclose this stuff immediately to the DRE to avoid any issues. And the same thing for the broker. All right, so what is DRE discipline? So usually if the DRE investigates something, what will happen is you'll usually get to start what's called an inquiry letter, and it'll be sent to the licensed person they want to ask questions on. And it usually says, we received a complaint about X. Please tell us what's going on. They'll ask for what's called a narrative about your side of the story, whatever the issue is, and then provide all these documents. Please call an attorney before you respond to that, because what the DRE is doing is a fishing expedition and they want to get as much information out as you as possible, and they are going to use that information against you if they can. A lot of agents tend to answer these on their own, and then once they get an accusation, come to the attorney later. And sometimes it's hard to put the spilled milk back in the bottle, right? And it's just human nature. We want to be helpful. And so a lot of times we tend to overshare. And so get an attorney involved up front, because that attorney also, not only are they going to create your response and make sure you don't say any more than you have to that might harm you, but they're actually going to audit that transaction at issue and let you know if there's any other potential exposure. So they're going to prepare you for it. And they're going to figure out a way to downplay it with the DRE if possible. I put in the Procedures Act here. It's in the government codes if you want to look at the procedure. But really, the big thing to be aware of is that the DRE can do anything from send you a warning letter, give you a cite and fine, They can suspend your license. They can have a suspension where you buy out of it, meaning you give them money, and as long as you don't violate within a certain amount of time, you don't actually have to be suspended. They can restrict your license, meaning that your broker has to give you more supervision and regularly check in with you, and the DRE will check in with you. Or they can full on yank your license. Um, and lastly, I put here DUI. I cannot stress this enough. Always disclose the DUIs. It's just one of those ticky-tacky things that I notice a lot of agents run afoul of because they think they don't have to disclose those. Always disclose your DUIs. And keep in mind, this is really important. The government here in California treats licenses as a privilege, not a right. Any license, whether it's a attorney license, a medical license, a real estate license. And so as a result of that, you don't have all the due process rights you do in regular court. Perfect example of this, and it frustrates me to no end, is going back to the example I gave earlier where, a real estate agent has their license suspended for failure to pay child support. You don't have a right to get those documents from the child or the health and safety department. Well, you won't get those in a case. The DRE will just tell you, no, we're not going to provide you what you're allowed. In any other area of law, you're getting those documents because it's your right to see what you are accused of. In administrative cases with the DRE, it's not the same. You don't even necessarily have the right to see everything you're accused of. It's a pretty horrifying process. And so again, this goes back to being proactive. You want to avoid ever having to face this situation with the DRE, one, but two, if you do find yourself getting an inquiry letter, responding to that inquiry letter correctly, upfront and quickly with the advice of counsel and with their assistance is key to try to avoid and downplay and at least mitigate the potential consequences. Because I will say DRE accusations are not cheap. Not only do you probably have to pay some fines depending on what occurs to you, but they make you pay all their investigation fees. So it's usually several $1,000s that you have to pay them to investigate you, which is just more salt in the wound, right? And so be proactive on how you address these. Going back to what happens if you do find yourself, an accusation was filed against you by the DRE and you find yourself going to hearing and the administrative law judge orders a restricted license. The good news is what a restricted license is, you can still practice. You can still go out and do transactions. The bad news is for you brokers is you guys remain responsible for them and have to be more involved, meaning that you are doing regular reporting on the supervision that you are undertaking with that particular agent to the DRE regularly. And so it's kind of like having a spyglass on you. The DRE is just looking at you a little bit more, which isn't great, right? You don't necessarily want that. So the good news though with restricted licenses is that restriction can be removed later after a certain amount of time has passed, as long as there's been no other violations. But it's a pain and it's not a cheap process. And so just be aware as a broker, if you ever take on somebody that has a restricted license, you're going to have to do this regularly reporting to the DRE. All right. Doesn't look like we have any questions so far. So let's continue. Let's talk about E&O insurance. E&O insurance is not a requirement for any brokerage to get. However, I would strongly recommend you get E&O insurance and get it from the jump. I have had cases where real estate agents come to me, it's like, help, I've been sued, or the broker comes to me, I've been sued. When I look up and they have E&O insurance, I say, okay, I'm going to help you tender this claim to your E&O carrier so you get coverage. And usually they get coverage. An E&O carrier may send you what's called a reservation of rights, where they say, look, we don't cover all of the claims you're being accused of, but we cover these. And as long as they cover something, they're going to pay for your attorney's fees, meaning your defense, and they're going to contribute towards the settlement and maybe pay the whole settlement. You'll want them to do that. My best day is when an agent comes to me and I tender that claim, and then the insurance carrier picks up, and then the insurance carrier retains their own attorney to represent them. So even though I don't ultimately get the case, I know my client is covered. I know they've got protection. My worst day is when I have an agent come to me and say, help, I've been sued. And I say, okay, do you have E&O insurance? And they say no, because then I have to have the uncomfortable conversation about, okay, you're gonna have to pay your attorney's fees and any settlement out of pockets. And depending on the case, that can be significant. I always warn all of my clients these days, whether they're facing a potential lawsuit or looking to bring a lawsuit. It's taking several years to get through the courts right now. The courts are just backlogged. It started to briefly get better right before COVID, and San Diego County in particular was getting more funding from the state. And so we were like, yes, we're going to get more judges. We were backlog shrinking, and then COVID hit. And now cases are taking even longer than they were taking before. And what that means is attorney's fees and costs ever increasing, not just inflation. All our vendors are more expensive now. And, attorney's fees have also risen. But when a case just lingers longer, people tend to do more work on it, and it just costs more money. To take a case to trial now probably costs on average $200,000 for an attorney. And so not having insurance is dire. And I realize when you start a company, insurance is not cheap at all. And if you are a brokerage that does a lot of transactions, there are chances you might have claims from here and there. And as a result, your premiums increase over the year. You got to bite the bullet. Have insurance. I cannot stress that enough. I had an agent last year who didn't have insurance, and she was very close to retirement. This was one of the last transactions she did, and she got nailed. I was able to get her out somewhat cheap, but still took time, effort, and money to get there. And that was time, effort, and money that was supposed to be her retirement. It made me feel sick, and I can only imagine how she feels about it to this day. And again, I still got a pretty good result for her, but it was still just devastating. So you want insurance involved. And insurance, insurance really covers any negligent services or failure to perform a specific insurance. Really, the only things E&O isn't going to cover is straight up fraud or forgery or things like that. But even if there is a claim that they do cover, and one of the nice things is when people file lawsuits, they allege a bunch of claims, because some claims are harder to prove. Fraud has a higher burden than, say, negligence. So they're usually going to allege both fraud and negligence, just in case they can't prove one, they've got the other, which opens the door for you guys to get coverage from your E&O carriers. And so you'll still get coverage even if everything's not covered. Keep in mind that CAR listing agreement does not tell the consumer you have insurance or don't. As some of you may have already kind of learned through being in the business, is that a lot of times people assume brokerages have insurance. Whenever there is a dispute over non-disclosure issues between buyers and sellers, you see the agents get sued a lot. And that's specifically because there's assumption that brokers have insurance and that they should be involved therefore. And so keep in mind, no one's ever told whether or not you do or don't have insurance, but most people kind of assume you do. If you have an E&O policy, know your terms, understand what's covered, what's not covered, what your limits are per claim, whether your policy is burning or not. And what that means is some policies include your attorney's fees as part of your overall limit on each claim. And so every time the more attorney's fees get spent, the less amount there is left to kind of settle the matter. So you want to know if you have what's called a burning policy. You want to know when your claim needs to be made. It might need to be made within the specific period. The good rule of thumb is whenever you get notice about a potential claim, notify your carrier right away, even if nothing's happened yet. Even if it was just like, I heard my agents telling me that the seller was griping about this and they questioned about whether or not we did the service correctly. You can put your carrier just on notice about something without actually tendering a claim yet. And doing that makes sure that you have coverage later, because there will be issues. There's always issues if somebody doesn't tell their carrier about a claim the moment they hear about it. I had another devastating case where I had a brokerage here in town where an agent received a demand letter. They did not tell broker immediately when they got the demand letter. And then 10 months later, the lawsuit comes and the broker's just beside himself. He hadn't heard anything about this. You got this, lawsuit. What do I do? He calls me. Unbeknownst to us, the real estate agent called up the E&O policy directly. I recommend don't ever have your agents talk to your policy adjusters directly. Just don't do that. It should go through the broker at all time. But the agent did, and then the agent admitted to getting that demand letter 10 months before. So that gave the opening to the insurance company to be like, well, we're not going to cover this because you're on notice and you failed to timely tell us about what was going on. That had devastating consequences to that company. So make sure you're always telling your E&O carrier about an issue the moment it comes. And again, it can just be notice. It doesn't have to actually be the tender of the claim, meaning that you've got a demand for money or you've been sued, which is when you tender. If you just hear about an unsatisfied person, you may want to let your carrier know. Um, Also know all the exclusions about your policy. That includes agents selling their own property or buying property for themselves if they're doing it under your license. A lot of times those are excluded. Property management may be excluded unless you specifically go and get a policy for that. So make sure your services match what you're covered for. And again, I know I've said this a billion times, but make sure your brokerage name is correct and your DBAs are correct on your policy. I have this come up a lot in all areas, not just with brokerages, in all businesses where, I have a client that's sued, they come to me and I say, hey, do you have insurance? Yes, they send me the policies. And then I'm looking at names I've never heard of. And now I'm trying to figure out how I can get them coverage without the insurance company saying, well, we never covered that specific entity. Um, Sometimes I can get cute with it and make it work, but not always. And so you want to make sure those names always match. And that should be an annual thing you're looking at. And remember, E&O is not workers' compensation insurance. These are two different things. All right. You may also want to get general business liability insurance, something to cover your premises, your business assets, things like that. So you want to consider that. This is again going back to this is why it's so good to have an insurance broker because you may be looking for multiple policies. Trust me, that is a lot of homework to do on your own. Brokers have great resources to get you the best rates. Similarly, if you're going to have a bunch of employees, you may want to consider an employment practices liability insurance that would cover employment law claims if they come up. Again, this may or may not be useful or necessary for you if you're really not going to have a bunch of employees or any employees. Automobile insurance. And again, automobile insurance, you want to make sure the carrier knows that you carry customers in the car if you do, or that people are going to be using this during business. And so you want to make sure the policy actually says these things. If your real estate agents have E&O or any kind of liability insurance, make sure you're named as an additional insurer. And by you, I mean the brokerage. That way, if you get sued for something that agent did, you can also tender to their policy. So that gives you another pocket to hopefully settle things that may put you in a situation where you don't have to pay attorney's fees out of pocket. Their insurance is covering that. Again, going back to property insurance, you may want actual property insurance for your space. Understand if discrimination is covered in any of your policies or other limitations. The reason I say that is, again, those Fair Housing Act claims, a lot of insurance policies exclude those because they consider that an intentional act, and a lot of times intentional acts aren't covered by insurance. Employment practices liability insurance typically does cover those because there's a lot of discrimination claims in employment law settings, but just be aware you want to check for that too, see if that's covered. And it may be that you might not find a policy that does cover those claims just because that is kind of one of those things that's industry standard they don't want to cover, but some do. So it might be out there. And lastly, I know I just mentioned it, but just have a broker help you. These are there's so many policies out there. There's so many carriers, and what they cover versus what they don't, can vary wildly amongst the companies. So just having a broker available, they can usually create like a matrix for you where you can kind of look at, a snapshot of what your potential coverage is along with the cost to really understand what's best for you. All right, and we're getting towards the end here. Thank you guys for holding it. Record maintenance. This is both the fun and obnoxious part, but this is a necessary evil. You need to maintain all of your real estate transactions, even the ones that don't close. And when I say maintain, it means you need to maintain all documents related to that transaction. That includes the drafts. That includes the final executed documents by all parties. That includes communications on that transaction. That's emails, that's texts. Going back to what I mentioned earlier, trying to create a culture where the agents aren't using text as much is key because emails are easy to download and put in a file. much quicker than it is text, and texts get lost. So make sure you are maintaining the entire snapshot of the transaction. The DRE requires that you maintain a transaction for 3 years from the date of closing. You must have those files available for DRE audit with reasonable notice. That also includes trust documents. These don't have to be physical files. These can be virtual files, but that means you need to have a server prepared to maintain all these items. I still have some brokerages that keep physical files. Most don't at this point, and that's fine. As long as you are maintaining these documents in full somewhere, make sure they are available. If they are on the cloud, make sure they are backed up, or, at least 2 times over, that you're not going to lose these in any way. Recommendation, you can also talk to your association. You can talk to CAR about software and its uses in relation to file retention. But the last thing I really want to say on record maintenance is, even though the DRE says keep your files for 3 years, lawsuits have what's called statutes of limitations for certain claims. And what that means is, if you want to bring a claim, say for breach of contract, you have a certain amount of time in which you must do that. Or say you want to do it for non-disclosure, you have a certain amount of time. When that time starts to run isn't necessarily the close of escrow date. It may be when you discovered the quote unquote false or misleading statement, right? And so if that's the case, your statute of limitations can be significantly longer than 3 years. For a breach of contract in California, it's 4 years from the date of the breach. For negligence or fraud, it's either 3 or 4 years from the date you learned or should have learned about the fraud or negligence. And so that, again, could be a year after close of escrow, right? And so I always tell my brokerages, keep your files at least 5 years. I would say 5 to 7 years is a good rule of thumb. And it's obnoxious and no one wants to keep files that long, but I have had the brokerage that follows the DRE rule like clockwork. They're fully compliant. They get rid of that file during year 3. They've complied. And then 4.5 years after that transaction closes, here comes the lawsuit. And guess what? The file's gone. So then what happens is we're left to rely on whatever we can get elsewhere. Hopefully escrow has kept some stuff. They may not have, though. They may have also purged. Title, same thing. Then we have to look to the buyer and the seller, and right, one of those people are probably the person that's suing you, and therefore they may not have kept all the documents that harm them. They only kept the documents that they think help. So these become real issues when you don't have the file later. So I would create an internal process where you're making sure that these files are being maintained for at least 5 to 7 years, and that there's backups if you're keeping them virtually, just in case there's ever a crash. All right, so that's our overall outline of today of how to create a brokerage. And again, we didn't cover every single thing, but we covered the big topics. I want to make sure the big thing, though, is that you take away from today is that there are these licensing requirements. You've got to create and govern your business entity. You got to deal with how you're going to handle employees and independent contractors, including the agreements and policies relating to both. That you have workers' compensation and make sure that that covers your salespeople. That you do understand your broker supervision requirements and where you can find those, and really where to find answers. That's not only your CPA and your attorney, but CAR Legal. CAR has memos on there. Your E&O carrier will have stuff. Your workers' compensation, carrier will have stuff. You have a lot of resources to cover these things and make sure you're getting the information you need. And again, be proactive. You don't want to wait until the issue comes up later. You want to ask the issues immediately. So again, last summary, also understand the revocation and suspension issues that could come up, because that's really going to come into play with how you supervise and train your salespeople. Make sure your policies and procedures touch on antitrust laws and do not call lists, as well as discrimination. Again, hot button issues these days, so you want to make sure you're covering them. And lastly, you want to make sure you're training your employees and your agents regularly, complying with any local laws, and making sure you have sufficient insurance and you're maintaining your files. All right, I'm going to do a stop share right now. And let's see, do I have any questions? All right, I got one from Lisa. If you want to start off working as an individual brokerage with no agent, are you required to have workers' comp? Um, I believe you should, and that's something I would check with your broker because you'd want it to cover you just in case. Because here's the issue is if you get injured at the job or at client's business, because you're working, your regular insurance may or may not cover it. They may say go through your workers' comp. And so you might want to have workers' comp, but that's something I would check with your broker to confirm. That is a good question. So yeah, I would go to a broker to get the most up-to-date information there. All right. Any other questions? All right, Shirley, are you there?
Yes.
I think I got another one. If you are already a licensed broker, can you start your own small brokerage just using a DBA? You're going to have a corporation set up, and that corporation can have DBAs, but the actual brokerage itself must be a corporation. A DBA doesn't stand on its own. It's just a trade name that a licensed business entity uses. And so, you can have a corporation that says your name, but then you come up with a snazzy trade name. And that's what you would register with the DRE as your DBA and make sure it's included on your E&O policy and registered with the county. But yeah, a DBA is not a standalone entity. All right, any other questions? All right, well, seeing no other questions, feel free, as always, to reach out. You can reach out to my firm. You can reach out to Car Legal with any questions, but I'm at White and Bright. My name's Melissa Engle. Our number is 760-747-3200. We're here in Escondido. We help all of North County. I am always happy to help you guys if you think of any other individual questions that pop up later. Because if you're like me, I always think of the question I needed to ask in the shower or when I'm walking the dog. Feel free to give me a call. I am always happy to help. Like I said, my goal is to make sure you guys don't get sued, that we are proactive and we're avoiding that and saving you guys money. So thank you for having me today. And I look forward to hearing from all of you in the future.
Thank you so much, Melissa. It was fantastic. Thank you.
Perfect. And then the other thing, I will email you the slideshow. I'm happy to share it if anyone asks.
Perfect.
I'm a
Thank
big
you.
fan of homework, so it's always good for me. I'm like, give me the list of what I should be doing. So if anyone needs it, they're welcome to have it. All right, yeah, we definitely have one person that wants it.
All right.
Perfect. I'll get
Thank
it to
you.
Shirley, and Shirley can get it to all of you guys.
Yes.
All right, guys. Well, thank you so much. You guys have a wonderful day. Happy early weekend, and I hope to see you guys soon at a live event.